Okay, everybody ready to proceed again? See you there, Marie. I take it you're ready to go?
Yep, I'm ready to go.
All right, thank you. If you can, you're acting for two of the submitters, as I understand it. So do you want to begin with your legal submissions?
Yep, thank you, Mr. Chair. Just a couple of points before I start working through the legal submissions on the issue of a site visit. Both Mr. Bartlett and Mr. Saville will address you when they give their evidence, but I can confirm that both of them invite you to go into their properties as well for the site visit this afternoon.
Thank you.
And yeah, just to note that there was nothing untoward or inappropriate about the timing of the provision of the personal lay evidence from both Mr. Saville and Mr. Bartlett. It was in accordance with the directions that we received, as Mr. Gordon pointed out, and in accordance with standard practice. So it just looks like there was just a little bit mix up with the notice that went to the applicant's party. So just working from the top, I just noted in my paragraph 2 who these submissions are in respect of, but just a correction, I hadn't quite picked up the subtlety that the land use consent for the otherwise unspecified building envelope had been removed. So there'll just be a couple of corrections through my submissions that land use aspect of the proposal's no longer part of what you're considering. And I don't think it changes anything materially from our point of view because of the intimate crossover between Chapter 24 and Chapter 27. In terms of my executive summary, the submission is that the application should be declined because the adverse effects of the proposal on the environment will be significant and more than minor. In particular, the proposal will have unacceptable effects on rural amenity, including noise, loss of privacy, light, smoke, reduced visual amenity, shading, and safety issues. And for that reason and others, the proposal was contrary to the objectives and policies of the PDP. The proposal will have an unacceptable effect on the submitter's rural amenity. The visual, shading, noise, and privacy effects that will result from an additional dwelling in close proximity to the neighbours are inappropriate. And in my submission, it's clearly contrary to the objectives and policies of the PDP. The proposed subdivision is far below the 80 hectare minimum lot size threshold. The LCU is recorded in the plan as being at capacity, and adding a further lot and dwelling will result in adverse cumulative effects on what is intended to remain a low density rural amenity area. And I listened with interest to Mr. Espy's presentation, and in particular, he made a comment that I can't see how there could be more subdivision here. He meant after this proposal. And effectively what he's saying is this area is either at or very close to capacity already. And in my submission, it is at capacity already. It's beyond that tipping point. And to authorise another subdivision to a 1 hectare size lot, which is a very small lot in the scheme of things when you look at what it's surrounded by, it would take this area beyond that tipping point. So I do a Part 2 assessment and focus on Section 7C, as did my friend Mr. Gordon, and the requirement to have particular regard to the maintenance and enhancement of amenity values, and that's particularly relevant to this proposal. Amenity values are defined in Section 2, and I think Mr. Gordon took you through that definition, so I won't read it out here. Paragraph 8, amenity values. It goes far beyond matters of visual amenity. Rural amenity is a key aspect of amenity values, being how a person appreciates and experiences their rural living environment. And as discussed in these submissions, we submit the proposal falls far short of maintaining and enhancing the amenity values of the site and surrounding area because of the substantial adverse effects on rural amenity which the proposal will generate for neighbours. Now, in terms of the non-complying status, I've approached this in a bit more of a structured fashion than my friend. Set out Section 104D there, but you'll be familiar with it. And you'll be familiar with the alternative gateways that this proposal has to get through before it can be assessed on its merits. In respect of the gateway on the objectives and policies, the key objective for consideration is 24.2.1, which requires that landscape character and visual amenity values are maintained or enhanced. Policy 24211 sits under the objective and requires that an 80 hectare minimum net site area be maintained. Now, my friend and I have taken quite a different approach to how the Bryle decision is of assistance to your decision making. In Bryle, the High Court recently considered and upheld the Environment Court's decision to grant consent for a 2-lot subdivision to below 80 hectares. Both courts recognised that for sites within the rural amenity zone below 80 hectares, any subdivision would inherently conflict with Policy 24211. And in terms of how the non-complying activity status and the policy was to be assessed for the purpose of Section 104D, the Environment Court set out the quote I've got there below. I'll just let you read that to yourselves. Good. So the courts in Bryle also recognised the importance of 24211 in the context of Chapter 24, and the High Court commented that the 80 hectare minimum lot size required by Policy 24211 is central to the purpose of maintaining or enhancing the landscape character and visual amenity of the rural amenity zone. The Environment Court emphasised that in light of the purpose of Chapter 24, policy direction in 24211 regarding minimum lot size was fundamental to the Chapter 24 framework and required the court to closely scrutinise the proposal. Another quote I'll let you read.
Okay.
So I submit that Bryle is authority that for a non-complying subdivision of less than 80 hectares in the rural amenity zone, a proposal can only be successful in passing through the Section 104D gateway limb A, if limb A can be achieved, as a proposal cannot pass through limb B. And that's the importance and the relevance of the Bryle decision, is that both courts found the proposal could not pass through limb B. It was contrary to that very central objective and policy in the chapter. So effects on in my submission, you can only determine this application on the merits if you first find that it gets through limb A, which is that effects on the environment must be minor or less. And therefore the proposal must be able to maintain, if not enhance, landscape and rural amenity values. There's no sliding backwards. As per the Environment Court's assessment in Bryle, the panel should give careful consideration to whether the proposal is in line with the purpose of the rural amenity zone. And we submit that it doesn't meet limb A because it will have greater than minor adverse effects on the rural amenity values of the submitters.
So just to stop you there for a minute. So that's the test. You got to meet one of the two tests. One is
that's right. They're alternatives. Yeah.
Or
yep.
not
minor or less. Yeah.
I understand you're arguing both of those have not met. Is that correct?
Yes, we're arguing both of those aren't met, and the High Court decision and the Environment Court decision in Bryle definitely found that the proposal was contrary to the objectives and policies because it was for a proposal of less than 80 hectares. So in my submission, the relevance of those two decisions is that we've got a proposal that's for less than 80 hectares. It is contrary to the objectives and policies of Chapter 24, so it can't get through that gateway test. So the only way for this application to proceed is if it gets through the minor or less on an effects basis gateway test.
Now, Mr. Gordon, I think, made the comment that his view, and maybe we're confusing it here, that the court come to the view that the 80 hectare minimum, call it that, is not a bottom line, that it reads like a bottom line as a policy. And although if it's simply an application for subdivision, even the subdivision policy is fairly well discouraging and only provides an exception for residential type subdivisions.
Yeah, well, it does read as a bottom line, and that's why the court found it couldn't get through the gateway test because of being contrary to the policy. But then on an effects basis, there are other policies that are relevant to the court's assessment, which my friend didn't take you to, and on an effects basis, it was still found to be appropriate by the Environment Court in that particular context. Very, very case specific, fact specific situation.
Now, sorry to keep interrupting your presentation, just the other thing that was put to us was that effectively, if you go through what is currently like an ODP for the operative plan framework, and you have like a lot series of boxes, it's well screened from public place ticked. It doesn't have an adverse effect on overall landscape values, etc., etc. It's a whole series of them. And as long as you have a tick in those boxes, then you can basically get around the 80 hectare minimum. That's what I understand was being put to us. But you're saying you don't think it does tick those other boxes?
Well, to step back a bit, both the High Court and the Environment Court, those extracts I've given you, talk about how important policy 24211 is, and because it was so central to the effectively, well, one of the terms, it's a prerequisite to consentability. It's basically the importance of 24211 to achieving the objective and the purpose for the zone as a whole. Significantly more weight has to be given to whether or not the proposal is in accordance with it or not, even if it ticks all of the other less important boxes, if you like.
So you want to carry on now with paragraph 20?
Paragraph 20, yeah. So this section, I sort of summarised the situation for both of the submitters, but before I do, because it's relevant to what I'm saying in this section, I want to pick up on another point made by Mr. Gordon a few times about the fact that the setback from boundary standard in the rural amenity, or in the Wakatipu Basin rural amenity zone, is 10 metres. And in my submission, that is completely irrelevant. You can't take that into account in your consideration. It doesn't establish any sort of permitted baseline, and that setback from boundary standard is only relevant to consideration of land use consents. It's only in chapter 24, not in chapter 27 for subdivision. This is a non-complying subdivision, but even if it was a subdivision that complied with the density of one dwelling per 80 hectares, it would still be a restricted discretionary subdivision at most under 27.5.9. And the first matter of discretion includes location of building platforms. So when you are considering a subdivision, whether it's non-complying or if it was a compliant subdivision, it would still be restricted discretionary, and you would still have discretion about how close a building platform was located to the boundary. So in my submission, it's not helpful, and it doesn't give you any accurate steer to take into account those comments about setback from boundaries in 10 metres. So moving on now to do you have any questions about that?
No, I think we understand that.
Yeah, okay. So there's no, sorry, I'll just round off the point. In the subdivision chapter 27, there is no setback from boundary standard at all that's relevant to the Wakatipu Basin rural amenity zones. There's setback from road standards, and setback from escarpment standards, and setback from water body standards, but it's obviously absent from a setback from a boundary standard. So it's a matter over which council has full discretion.
Okay.
Okay. So Mr. Bartlett lives with his family at 776 Mulligans Road, directly south of the sites, sharing a common boundary. And the property sits on a slope rising from the site to the south, so his house sits elevated above the site. The Bartlett house is 2-storey with indoor and outdoor living areas on the second floor, facing north, looking out over Coronet Peak and towards the applicant's existing dwelling and proposed building platform and new dwelling. As can be seen from the plan, the proposed building platform for Lot 2 is approximately 24 metres from the Bartlett's boundary and 53 metres from the Bartlett's dwelling. Due to the elevation of their property, the proximity of the building platform and the need to trim the boundary trees on the applicant's property to between 2 and 3 metres, any dwelling built on the building platform will be visible from the Bartlett's home. And I also just ad lib there, and that's just the building platform. When you take into account the curtilage area and anything that could appropriately be located there, like trampolines and washing lines, swimming pools, barbecue areas, storage sheds, parking areas and caravans and camper vans, all of those things that could quite legitimately be located on the curtilage area, the actual encroachment towards the Bartlett's property of domestic activity and visual effects is a lot larger than just the building platform. So that proximity of coming within 53 metres of the Bartlett's dwelling is in contrast to the existing environment, where the nearest existing dwelling to the Bartlett's dwelling is the Saville dwelling, which is approximately 95 metres away. So we're going from 95 to about 54. The common boundary is lined with evergreen trees on the applicant's side. The Bartlett's driveway runs alongside the common boundary for about 50 metres before turning up towards the house. And the trees currently cause shading issues and ice build up on the driveway, which I'll go into detail later in my submissions. And Mr. Saville lives with his wife at 700 and 702 Mulligans Road, directly to the west of the site, sharing a common boundary. Saville's dwelling, the kitchen and living space, is 12.5 metres from the common boundary. The proposed building platform on Lot 2 is approximately 43 metres from the Saville boundary and 54 metres from the Saville dwelling. Currently, the nearest dwelling to the Saville dwelling is the existing dwelling on the site, which is approximately 80 metres away. And as can be seen on the proposed plans, the proposed driveway for Lot 2 runs east to west across Lot 2, with new incoming traffic facing towards Saville's property and their living spaces. The driveway then curves around before turning up to the proposed building platform, meaning that all traffic will pass in close proximity to the shared boundary, and both incoming and outgoing traffic will face towards the Saville dwelling at some point along the driveway. So now I turn to the non-compliant gateway in more detail. And looking first at Lim A, the submitters are already experiencing a loss of rural amenity in the existing environment due to proximity of the houses in this rural cluster and the behaviour of tenants renting the applicant's existing property. And you'll hear from my clients directly about those effects. As the submitters explain in their evidence, they have experienced noise issues with the previous 3 tenants, all of whom have created excess noise on multiple and frequent occasions despite formal noise complaints and complaints to the applicant. New tenants have not resolved the issue, which continues to be an ongoing frustration for the submitters. The existing dwelling on the site is 80 metres from the Saville dwelling and 120 metres from the Bartlett dwelling. Considering the extent of adverse noise effects experienced at that distance, a second dwelling at a higher density, 26 metres and 67 metres closer to the submitters' properties respectively, which is expected to also be rented, will make the noise issues far worse and will result in increased vehicle noise. Noise is particularly a concern for Mr. Saville due to the proximity of his kitchen and outdoor barbecue area to the proposed building platform. And you'll see that when you go out on your site visit. Similarly, it's a particular concern for Mr. Bartlett as his dwelling is elevated, looking down over the proposed building platform, with noise not only travelling up as it does to his living spaces, but also rebounding off the rock face slope at the back of his property. The applicant's planning evidence comments that rural farming activities are permitted on the site and they produce noise, and so the submitters cannot expect a totally quiet environment. And while this is the case, it is submitted there is a big difference between rural farming noise in a rural living environment, and excessive urban type noise. The first is expected and welcomed in a rural living environment, while the second is exactly what the submitters were aiming to escape when choosing to live in a rural environment. On light pollution, the submitters will experience light pollution from vehicles and indoor and outdoor lighting due to the proximity of the proposed building platform and location and facing of the driveway. Currently, this section of the site is entirely dark at night, so the change will be significant. The proposed screening trees will only partially screen light pollution and cause other issues. The majority of these trees are deciduous, so will provide very little screening, if any, of light pollution in the autumn and winter months. Smoke and dust. Residential activity on proposed lot 2 is likely to include smoke from indoor and outdoor fires and dust from vehicle use of a gravel driveway. And as Mr. Bartlett explains in his evidence, previously when fires have been lit on the site, the smoke travels up to his dwelling and affects him and his son, who both have respiratory problems. A second dwelling on the site will increase the frequency of smoke pollution from what would have been the occasional controlled outdoor burning to what could be daily indoor and outdoor fires in the winter months. And as Mr. Saville explains in his evidence, he is concerned that the close proximity of the Lot 2 driveway turning space to his kitchen and outdoor barbecue area will increase dust pollution to his property and affect their ability to enjoy their outdoor living space. So looking at the nature and scale of the development proposed. When considering the potential adverse effects of the proposal, it's important to consider the scale of the development being proposed. The existing site is 2.66 hectares, and obviously I've excluded that section 6. And the applicant proposes to create 2 lots of 1.6 and 1 hectare. This is in a zone where the intended minimum lot size is 80 hectares. The lot sizes proposed are comparable to the lifestyle precinct, where further rural living development is anticipated and subdivision is provided for to a minimum average lot size of 1 hectares as a restricted discretionary activity. Activities within the Wakatipu Basin where this minimum applies, so you can get a feel for what that density looks like, is include the Hawthorn Triangle in the northern end of Lake Hayes. Now, these precinct zoned areas are clearly not rural in character. They have a different purpose and a different rural amenity than the rural amenity zone. High density clustered development is not contemplated by the rural amenity zone. The purpose of the rural amenity zone is to maintain or enhance the character and amenity of the Wakatipu Basin while providing for rural living and other activities. In my submission, this proposal neither maintains nor enhances the rural character and amenity of the subject area. I also, when we were looking at the page of the 42A report that I think Ms. Afifi took us to, which we had the map showing the different lot sizes surrounding the subject site. So that was on page 101 of the 42A report agenda document. If the site is developed down to a lot of 1 hectare, that becomes the second smallest lot in this cluster. And Mr. Bartlett's lot is the smallest lot at 0.77 hectares. So it brings the average lot size of the whole cluster down. It will no doubt make other neighbours be curious as to whether or not they can get their lots down to 1 hectare. And there's a few that have got the opportunity to do that if you're just looking at the basic lot size. Go back to my paragraph 43. So when buying a home in the rural amenity zone, people have a legitimate expectation that rural character will be maintained because that's the purpose of the zone, and that the rural amenity they experience will be maintained. This is certainly the case for the submitters and their families who brought along Malagans Road for a rural living environment. As will be discussed later in these submissions, given the zoning of the site and the identification of the Malagans Road area as having a very low capacity to absorb additional development, this expectation remains legitimate and is upheld by the PDP. It is submitted that in this case, the proposal cannot fulfil the purpose of the zone because additional rural living can only be provided for at the expense of the character and amenity of the site and the surrounding area. In terms of visual amenity effects, the proposal will result in adverse visual amenity effects for both submitters. For Mr. Bartlett, a view shed analysis from his outdoor living spaces to the proposed building platform has been completed and is attached to Mr. Hansen's evidence. And that view shed analysis shows that if the trees along the common boundary between the site and Mr. Bartlett's property are maintained at 3 metres, which is now proposed by the applicant, substantial portions of the proposed building platform will be visible. Even if the trees are maintained at their current height of 5.5 metres, parts of the building will be visible from the western and eastern decks. It's important to remember these are not long-range views. The proposed building is in close proximity to the Bartlett's dwelling, and the indoor and outdoor living spaces of the dwelling look directly towards and down onto the proposed building platform. The dwelling constructed on the proposed platform will result in a significant change to the Bartlett's visual experience when looking out towards Coronet Peak. So the view shed analysis models visibility of the entire building platform as opposed to the proposed building, which when there is a proposed building, the applicants volunteered a consent notice of 500 square metre limitation, which coincides with the standard in the plan anyway, so that sort of doesn't make a difference one way or another necessarily. But obviously, because we don't know where on the building platform the dwelling will eventually be, you can only assess realistically the effects of the whole platform. And I'll just, you can delete the next sentence about we note this is strange and go down to regardless, the last sentence. Regardless, the view shed analysis illustrates the extent of the building platform that will be visible from the Bartlett property, which leads to the conclusion that at least some part of the building will be visible from each viewpoint modelled. The applicant has proposed a change to the maximum height of the building on the proposed building platform to reduce visibility, and while that intention is appreciated, this change will not necessarily reduce overall visibility. The visibility of the northern part of the building platform will not be reduced due to the ground contour sloping to the north and the viewpoints from the Bartlett property being elevated above the building platform. And Mr. Hansen will be able to explain that much better than I if it is an issue. In relation to Mr. Saville's property, the applicant's proposal is to screen development by increasing the height of the planting near the boundary with his property. The hedge along Mr. Saville's property is currently 1.5 metres tall, and the applicant proposes to maintain it to 5 to 7 metres. Now, while this may reduce visual amenity effects of seeing the proposed residential activity, it will create other adverse effects. The broader views to the surrounding area and Coronet Peak will be affected if the trees are allowed to grow and are maintained at a greater height. And higher trees will impact solar gain on the Saville dwelling, particularly morning sunlight, increase shading, reduce openness, and create a greater sense of closure and affect cold and dampness in winter months. Now, moving on to this tricky issue of the shading of the driveway. As is detailed in Mr. Bartlett's evidence, the evergreen trees along his shared boundary with the site cause shading issues in the winter months. When allowed to grow beyond 2 to 3 metres in height, trees cast a shadow over the Bartlett's driveway for a number of hours of the day, which results in ice buildup. The issue can occur from early June through to late September. And the ice is a serious issue for the Bartletts. It prevents ordinary use of their driveway and property, as they often cannot drive up the last part of their driveway, so have to park further down and walk up to the house. And it is a risk to their health and safety. They themselves or their vehicles have slipped on the ice, and in the past, ice has prevented ambulances from accessing the house in emergencies. Mr. Bartlett had an agreement with the previous owner of the site to keep the trees maintained at 2 to 3 metres in height, and Mr. Bartlett would undertake the trimming himself. In 2021, the applicant would not allow the trees to be trimmed unless Mr. Bartlett signed an APA for this consent application. And at their current height of 5.5 metres, they caused ice build-up throughout this previous winter. Because Mr. Bartlett has not been able to reach agreement with the applicant to keep the trees trimmed, he intends to exercise his rights either under the RMA or the Property Law Act to require the trees to be maintained at 2 to 3 metres. And the applicant has been advised of this, and the the documents, if required under the Property Law Act, have been drafted. Mr. Hanson has completed modelling which shows that with the trees at 5.5 metres, there is shading over the driveway between 9 AM and 3 PM in the months of May, June and July, and partial shading in the months of April and August. His analysis indicates that the trees need to be reduced in height to 3 metres to avoid shading at the winter solstice at 1 PM. At 3 metres, there still would be partial shading between sunrise and 1 PM and after 1 PM until sunset. So practically what this means is that the trees need to be able to be trimmed to 2 or 2.5 metres in height so that there is time between trimming and growth back to 3 metres so that the trees do not need to be constantly maintained. My friend submitted that the issue of the height of the hedge is it's a matter of the existing environment that you have to take into account. And he submitted that it would be a benefit to the Bartletts if this consent is granted with the requirement to trim the hedge. But with respect, it's simply an obvious part of the consenting strategy for the site. Because unless Mr. Bartlett is forced to go to the Property Law Act to get an order for the trees to be trimmed because of the safety issues that they are causing, there is no legal requirement for the trees to be trimmed. There was a previous neighbourly arrangement for the trees to be trimmed, but that neighbourly arrangement hasn't been able to be reached with the current owners. So it's unfortunate that this is part of a consenting strategy because it makes your decision and my submission quite difficult. But regardless, do be aware that there is a process under the Property Law Act to get an order for the trees to be maintained at a current height if the Bartletts are forced into having to take that further step. So in my submission, it is submitted that the shading issue is an effect on the environment, which the panel can have regard to under Section 104. And while the shading is an effect of the existing environment, it would be perpetuated and worsened by the proposal if it required the retention of the boundary trees at any height above 2 to 2.5 metres. Now, finally, and this, not finally, but looking at the appropriateness of relying on screening vegetation to mitigate effects, we agree with Mr. Denny's comments that relying on screening alone to address visual amenity effects is not ideal. We submit that relying on extensive and proposed vegetation as the only measure to reduce adverse visual amenity effects is not an acceptable solution. It is not a complete solution because many of the trees are deciduous and will not provide screening year-round. The trees result in other adverse effects described in these submissions, in particular shading issues for both Mr. Bartlett and Mr. Saville. And screening does not resolve other adverse effects such as noise, lighting, smoke, and loss of privacy. And I submit that in terms of the weight to be given to the effects on the neighbours, the effects of the proposal on the rural amenity of the neighbours is and should be material consideration under Section 104(1)(a). And that is the whole point of affected parties such as these families being given the opportunity to present evidence to you on the effects on them. So that part of my submissions addressed the first limb or the first option of Section 104(d)(a). Then my submission that does not get through the minor or less effects gateway. And now I turn to look at the second limb, which I touched on briefly at the start. Section 104(d)(b) is the proposal contrary to the objectives and policies of the PDP. Now, my friend took you through where the Environment Court hearing on the text of Chapter 24 is at, and in particular that the wording of Policy 24.2.1.1 is a very live issue in front of the court and then where the council is currently landed. And I just want to be clear that whilst those legal submissions from the council might be a relevant matter, their relevance does not go to your assessment under Section 104(D). It is not relevant to your assessment of the gateway test that council in the middle of another hearing has proposed an alternative set of wording. You may very well find though, if you get through the gateway, that they are relevant under the assessment on the merits in section 104.3. But I think it's important to take a fairly disciplined approach to the assessment of that gateway test in these circumstances. I also, sorry.
Let's interrupt briefly there. It's actually, yes, an issue that's concerning us a little bit. I want to be absolutely clear what you're saying there. You'll recall that it was commented to us that, well, effectively we're in the middle of a course and literally in the process of making a decision at the moment, the outcome of which we don't know. We have evidence that was given to us this morning, that's the right word for it, put it this way, we have a statement made by a council planner to those hearings, basically would, well, I'm not about passing a judgment here, but it would pull the rug out completely from under what the current provisions in the plan say. It would basically be almost a reversion, if not a full reversion, to the ODP provisions. Now, you're saying we're applying the gateway test here. I just want to be clear what you've just said previously as to what our correct approach to this is. So we've got two limbs.
We've got two limbs. Limb A, which is the effects limb, are effects minor or less.
And
I've just taken you through that.
Yeah.
And I submit we don't get through that because the effects on the Savills and the Bartletts are more than minor. So you look at limb B. Now, when you're looking at limb B, you can only look at what the objectives and policies in the plan say. And at the moment, it's the form of 24.2.1.1 that refers to not having subdivision below 80 hectares. Now, my friend said when he raised what council have said in their closing submissions, that it was a relevant matter under section 104.3. So that was on my friend's assumption that you'd first somehow gotten through the gateway test, because it's only once you get through the gateway test, then you can look at other relevant matters under section 104.3. So we're effectively on the same side here. It's just I'm stepping you through it a bit more slowly and making sure that we don't fuzzy, we're not too fuzzy about things. The gateway test has to apply 24.2.1.1 as decided in the decision version. If you get through the gateway test, you can look at my friend's submissions about the council's closing submissions in the Environment Court and give what weight to that you will.
Thank you.
And I also just want to respond to a few other points that are relevant to this issue. There was a comment I think made by, I'm not sure if it was yourself or Mr. Gordon, that that the 80 hectares is effectively not relevant throughout the basin because most lots are smaller than 80. Now I was in this topic hearing as well. We looked at that issue in a lot of detail, and it was confirmed that only in LCU 1, so this LCU, and LCU 20 are there lots where the 80 hectare threshold is meaningful. So there's only 2 LCUs that have lots that are greater than 80 hectares where that rule and that policy really have bite, because you could still do a compliant subdivision in LCU 1 and LCU 20. So that 80 hectares isn't completely meaningless over the basin. It is meaningful for LCU 1 and it's meaningful for LCU 20, which is the Crown Terrace. And the other important point is that council are not agreeing in their closing submissions on topic 30 to get rule of the standard in the subdivision chapter. So there's no suggestion that the reference to 80 hectares is going to disappear completely in the rules. So it's still there as a live standard. Council hasn't fallen on its sword in that regard. So I don't want you to get the impression that it's going to completely disappear from the plan framework in all likelihood. What we do know is that for LCUs where there is a medium or medium to high capacity to absorb development recorded, the council are agreeing to smaller lot sizes as being the lot size standard, not 80 hectares. But for
smaller specified area than 80 hectares.
Yeah.
Oh, okay.
Yeah, but for the very low, which is LCU 1, and the low to medium, so that these are all the categories for those LCUs that are very low, like this one, low or medium low, there is no concession from the council to remove that 80 hectare trigger in the subdivision chapter rules and in the density rules in chapter 24.
Now, because the case has been put to us this morning, it's occurred in other parts of the district, not on chapter 24, but like it's an area in the ONL west of Wanaka where you've got existing pattern of subdivision, which is already open for whatever reason, it's got small over the years. And that's the argument that's been put to us here, where you've got a subdivision pattern which is different to most of the rest of LCU 1. In other words, it's some kind of, I suppose, an anomaly. It's a cluster of high density, relatively high density rural subdivision compared to the balance of LCU 1. So is that something you'll go on to address as well?
Yeah, actually I do. I think I used the land use planning study to address that point. Yeah. Sort of.
Well, I'm trying to derail your train of thought.
No, that's all right. I'm derailing it quite well myself. Okay. So paragraph 65. So the site zone rural amenity zone, it's an LCU 1. We talked about that. We talked about the zone purpose. We're all on the same page that the word is now or and not and. But anyway, that's just the moving target that we're dealing with constantly. And it's currently worded 24211 requires an 80 minimum net site area to be maintained. That's the policy. And then there's the rule that I was talking about before, 2761, which sets the standard. And if you don't comply with it, you're non-complying. In policy 24213 is similarly worded to objective 2421, but is specific to the landscape character and visual amenity values described in schedule 24.8 for the specific LCU. So the policy is that ensure that subdivision and development maintains or enhances the landscape character and visual amenity values identified in schedule 24.8. Some of the provisions of chapter 24, namely the objective and policy framework applying to the rural amenity zone, excluding the lifestyle precinct, remain subject to appeal in topic 30, and that's what we've been talking about. Another relevant policy that hasn't received much attention today, but particularly when you're thinking about setbacks and how much closer this proposed dwelling would be to the neighbours, it's like, nearly halves the distance to the other nearest dwelling, is policy 24211, which is requires that a sense of spaciousness be maintained where buildings are subservient to natural landscape elements. I've set it out for you there. This proposal increases the density of the rural living cluster far beyond what is contemplated for the zone. The degree of spaciousness that currently exists will be reduced, and the sense of enclosure will be further affected by increasing the height of existing vegetation as proposed, particularly for the Savills, blocking views to Coronet Peak and shading from morning sun. And back to the 80 hectare minimum lot size, the council's primary solution to ensuring that adverse cumulative effects in the exceedance of capacity does not occur is through this minimum lot size of 80 hectares. And throughout the topic 30 proceedings, the council has been clear it is unwilling to move away from the 80 hectare minimum lot size policy or rule for the very low, and low to moderate capacity LCUs. And on this point, I guess my emphasis is on the rule that I explained. Council might be proposing alternative wording for the policy, but council are not proposing to give up the application of the 80 hectare rule for the very low, and low to moderate LCUs. Because in council submission, this rule and policy approach ensures subdivision and development that will not maintain landscape character and visual amenity values will, words missing, be strongly discouraged. The 80 hectare regime was recommended by landscape and planning experts who authored the Wakatipu Basin Land Use Planning Study. They reviewed the extent of existing and consented development in the rural amenity zone, estimated the extent of additional development that could be accommodated in each LCU, and determined that a minimum lot size of 80 hectares was appropriate to strongly discourage further development where there was no further capacity in the rural amenity zone. I'll just let you read out that long extract there. Okay, thank you. Paragraph 76. So this is what that policy I referred to earlier refers to maintaining and enhancing the values set out in the Schedule 24.8. So the lists LCU1 as having a very low capacity to absorb development. The site itself and the drafting of Schedule 24.8 for LCU1 are not subject to appeal under the PDP. There's no appellant that's seeking to change the description in LCU1. So while there are outstanding appeal points regarding the drafting of policy 24211 and the 80 hectare minimum lot size regime, these appeal points are not being actively pursued with respect to LCU1. In terms of constraints on additional development, Schedule 24.8 is clear that the LCU is highly sensitive to additional development. It is also clear that the proposal does not offer any of the potential opportunities and benefits associated with additional development in LCU1, which would result from an appropriate proposal. And so I've set out an excerpt from 24.8 to show you what I mean. So as per the zone purpose, Schedule 24.8 is a tool that assists with the identification of the landscape character and amenity values that are to be maintained or enhanced. And it's clear from the LCU1 description that any further development in LCU should be considered incredibly carefully, that the LCU does not have further capacity to absorb subdivision and development of small scale lots, and that this is certainly not the intention as indicated by the zoning and the capacity rating. As discussed, the existing parent lot is 2.6 hectares and the proposed lots will be 1.6 and 1 hectare respectively. Lots of this size are not the larger scale lots referred to in Schedule 24.8. That reference is to lots greater than 160 hectares, which could be subdivided as a restricted discretionary activity, of which there are a few in LCU1. And as per Appendix K of the Wakatipu Basin Land Use Planning Study, a capacity rating of very low corresponds to a situation where additional built development will have a significant adverse effect on the landscape and visual amenity values of the unit. And the study recommended that no additional development be encouraged within units with a rating of low or very low. And then I've set out what it said there in respect of LCU1 specifically.
Thank you.
Now, just briefly on, the para 85, the fact that the proposal is to locate an additional dwelling within an already established cluster of rural living does not make the proposal consistent with the objectives and policies on the PDP and does not mean that the effects, particularly on the neighbours, are acceptable. These submissions have traversed a number of adverse effects on the rural amenity and visual amenity values of the neighbours that will occur precisely because of the proximity of the proposed dwelling to the surrounding existing dwellings, which makes it clear that this cluster of rural living has reached its capacity and cannot absorb any increased density. Collectively, the additional density and adverse effects will tip the scale so that the proposal will exceed the capacity of the area and result in adverse cumulative effects. As such, the proposal is inconsistent with the objectives and policies of the PDP, in particular 24211, 213 and 2111.
Yeah, so the point you've made in chapter 85, that's a fundamental point of difference between yourself and the applicant submissions, isn't it?
Well, yes, it's hard to tell because the applicant also, it comes from a fundamental point of difference on what the scale of effects are on the neighbours, as much as anything, because that, yeah.
Yeah, because basically what they're arguing is, rightly or wrongly, is that the character of that area, that cluster, people keep calling it, is different to the great majority of what LCU1 is.
Mm.
Yeah.
But I think as I understand it, that argument is more in relation to landscape effects on landscape and character at a broader scale, not the effects on the people who live there and their rural amenity and their visual amenity values.
I can see what you mean by that distinction, yeah. Okay. Yeah, I think that makes it clearer.
Mm. So the next section, I set out the relevant provisions in respect of water quality that you'll be familiar with. I don't propose to read that section out necessarily. The commissioners are obviously live to the requirement that this proposal has to be consistent with an improvement in water quality in the Lake Hayes catchment. And you've asked some technical questions of the experts on that point, and I suspect you're going back to the council's experts as well on that point. So I wasn't going to read out that section. I just note in paragraph 93 that the submitters consider that despite amendments that have been made in terms of addressing water quality concerns, they do still have a concern that additional development will not contribute to improvements in water and that further protections are required. And then a brief noting on weighting, which I don't think is too contentious. And we agree with the section 42A report that more weight should be afforded to the PDP than the ODP. And we extend this to say that substantial weight should be afforded to the PDP. While the rural amenity zone is still subject to appeals that challenge the policy regime as a whole, and the proceedings are ongoing, the appellants to topic 30 of the district plan are not actively opposing the zoning capacity rating or 80 hectare minimum regime for any land within LCU1. So whilst there's technically appeal points that are relevant, there are no active appellants have any interest in LCU1 seeking any change to the regime there. The council's position is that it supports the zoning capacity rating and 80 hectare regime for all land within the very low to moderate LCUs, and as such, the Chapter 24 framework can be effectively considered beyond challenge for LCU1, and so very little weight needs to be given to the ODP. in terms of benefits and costs, if you were to do a bit of a balancing exercise, not that that's be all and end all of your assessment, obviously, but we submit that the benefits of the proposal do not outweigh the costs to the neighbouring landowners. The benefits of the proposal are limited to the applicant. The proposed additional dwelling is not intended as a family home, rather that's anticipated it will be a rental property. Therefore, subdividing well below the anticipated level of development for the zone and adding an additional dwelling to a rural area, which is already at capacity, is proposed to achieve a purely economic outcome for the applicant. The economic benefit to the applicant does not outweigh the costs to the neighbours of adverse effects on their rural amenity, particularly considering the adverse effects are numerous and significant, and that rural amenity must be expressly maintained or enhanced in accordance with the purpose of the zone. Then I round back to part 2 in case you decide you need to look at part 2, and submit that it does not meet any of the 3 limbs of section 5.2 of the RMA, and as I started with, it also does not achieve section 7 of the RMA, which is maintenance and enhancement of amenity values. So we submit that the proposal should be declined. It's inappropriate from an effects perspective, and it is contrary to the objectives and policies of the PDP, and we can see no workable solution in which a dwelling on proposed lot 2 can be absorbed into the environment without resulting in significant adverse rural amenity effects on neighbours. If the existing and proposed vegetation is retained at its current height or greater, while visibility may be partially resolved, other adverse effects such as noise, lighting, smoke and loss of privacy will not be resolved, and new adverse effects will arise, such as increased shading, reduced sunlight access and a greater sense of enclosure. And unacceptable shading effects and dangerous ice buildups will continue to occur on Mr. Bartlett's driveway. If the existing vegetation is maintained at an appropriate height, being the existing 1.5 metre high hedge along the Saville boundary, and maintaining the trees at the Bartlett boundary at 2 to 3 metres, then visual amenity effects will be more than minor, and other effects such as noise, smoke and loss of privacy will be exacerbated.
So my previous questioning earlier on I was perhaps focusing on 24.2.1.1, but now we're really only looking at 24.2.1.4. Is that what you were saying?
No, not.
I wasn't quite clear about that at the start of the presentation. I hope I misunderstood you.
Right, sorry, no, 24.2.1.1 is definitely relevant, as is 24.2.1.3.
Yeah, because it's a proposed building platform.
Yep.
Yeah, okay.
And 24.2.1.11 about spaciousness.
Yeah, which is the amenity issue.
Yeah.
Amenity issue.
It's a spaciousness policy, yeah.
When I asked the question this morning of Mr. Gordon, I used the term, well, I think you were 24.2.1.1. There was a debate about 27.2.1.4. So I used the term as like a king salmon.
Oh, yep. Yep.
Is that overcooking it?
Oh, no, well, that's 24.2.1.1 is a very directive policy. Yeah. And that's how everybody's been reading it. So whether it's quite as far as king salmon and avoid, I don't think either the Environment Court or the High Court in Bryall quite went there, but they certainly read it as being very directive and very black and white, and that is why our reading of those decisions is that simply because that Bryall the subdivision was less than 80 hectares, it was contrary to that policy.
Yeah.
In the gateway.
Yeah, because it seems to me that if, in terms of the argument put in support of the application, it seemed to be a case of saying that if you come up with a true good and worthy application in terms of landscape impacts and rural amenity,
yep,
that gazumps the 80 hectare thing. You balancing again?
It finds, that there is a consenting pathway if the values that are set out in both the policies and the assessment matters and the Schedule 24.8. There's a consenting pathway, even if you are below that 80 hectares. That's what the Environment Court effectively said. So an effects-based pathway, yeah.
Okay.
I wouldn't call it a balancing approach. I'd just say it's a pure effect-based pathway. If you have, you know, effects that are completely acceptable in the context of what's set out to be protected in the rural amenity zone, then there's a pathway there.
Yes, that's the question I asked of Mr. Fifi this morning. There's various excerpts of the evidence, what I think I noticed at the time, where it appeared to me she had to undertake it as a balancing exercise. At the end, basically, it gazumped the minimum area standard.
I didn't understand that Judge Hassan undertook a balancing exercise in that decision on Slope Hill Road. I understood it to be an effects-based evaluation.
Yeah. Okay. Thank you.
Commissioner Nixon's answered most of mine, asked most of my questions, but I just had the one, just wanted to clarify the safety issues. Is that arising from the shading on the driveway? Is that what the safety issues are that you've?
Yes, yeah, that's the ice formation on the driveway. Yeah.
Thanks. That was all I had. Thank you, Ms.
Okay.
Galloway.
Thank you. All right. So
Any witnesses?
Yep, no, first witness is Mr. Hanson with his pre-circulated expert evidence.
Good afternoon.
Good afternoon.
We probably can, to start with the evidence, some of the sort of background we probably can sort of skip through a little bit, but then I can explain what I was engaged to do. There's two matters really. One was the shading that has already been discussed at some length, and one was the view shed analysis. So really what I was tasked with doing is quantifying that in a slightly sort of mathematical way so that we could make a good assessment as to what those effects were. So maybe if we could jump to the evidence. Starts with obviously the methodology. There's quite a reasonable amount of sort of technical information in there. I'm not sure if we need to dive into that in any detail.
Well, I suppose it's a bit like the recession plane diagrams that the developers sometimes do in urban areas. Same kind of thing.
That's correct. Of course, it takes into consideration the topography of the surrounding environment. Hillsides. It's probably more 3D than diagrammatic recession planes based on a horizontal surface. This is based on the actual ground contour, if you like. So yeah, and then obviously the environment's built in a computer model whereby we can make measurements and extract information to present these points about what can be seen or how far the shadow will cast at certain times of the day and the year. And obviously we've tried to make that as precise as possible given the methodology, survey equipment, drones, other data available to give the best representation possible of what the effects are, I suppose. So possibly we can jump onto the assessment. In other words, probably what everyone's interested to know is what the plans and the sectional views are showing or demonstrating, because that might be where the questions lie. And if we have them in front of us, the first one was the shadow analysis. And in plan view, it shows obviously the extents of the shadows from sunrise through to sunset on the winter solstice, but it also shows the extents of the shadows at other times of the year. And sectional views demonstrate the same, but I guess if you're looking along the lines of the shadows, if you like, to put in context the hedge and the boundary and the driveway, etc. And what we've demonstrated or concluded is that, yes, that the hedge would probably need to be at 3 metres high to avoid shading at the winter solstice at 1 p.m, but there would still be some shading outside of that on the shortest day.
So what height have you based this on for the, is that the height that the applicant's suggesting it be at in order to provide screening? So in other words, the higher level, isn't it?
So this is just for the shading. So
yeah.
3 metres at the shortest day at midday would mean that there'd be no shadow cast on the driveway, but other side of the 1 p.m. there would be some shading on the shortest day.
Yeah, I can see that.
So from there, obviously the next exercise was the view shed analysis. In other words, what Mr. Bartlett could see from key locations at his residence when looking towards the building platform envelope, which is a mathematically defined surface with a horizontal datum plus 5.5 metres vertically, and rectangular shape of 1,000 square metres. So that shape was built in the model, and then we analysed those viewpoints from Mr. Bartlett's property at that building shape. And those drawings then do show to what extent in plan and section a building, if it was built in that platform, would be visible. And probably the bits that would be mostly visible are actually at the northern end. Marie touched on that in her evidence, and that because the ground slopes away, but the building envelope is level. As we get to the outside, Mr. Bartlett's property is looking down on top. You'd see a leading edge if it was built to the full extent of that platform. And that can be seen on the sectional views, or it's been illustrated by those lines of sight, if you like.
Have you done that work based on the applicant's proposed RL 427 or original ground level? That's
correct. So we've done 427 plus 5.5 is 432.5, but we've also dashed a 5.5 metre rolling ground level as a comparative exercise. So that's shown on the section views as well. And section B actually shows probably quite well that the rolling height plane following the topography dips down at the northern end, whereas the horizontal datum shows that it's higher than the rolling height plane.
Mr. Hanson, is that shown on the view shed, the proposed cross sections?
Correct.
Okay, and that shows the rolling height and the RL measurements.
Yes, so the RL measurement or building platform is a blue dashed line,
yeah,
and then a grey dashed line. It's labelled 5.5 above existing ground level.
Okay.
So yeah, the methodology was described. That's what we have assessed in terms of those viewpoints from Mr. Bartlett's key views. And I think what that concludes is that although Mr. Espy's analysis of the visibility was based on his viewer points and his photographs, a potential bulk of a structure is probably larger than he was assessing, and may have underestimated it a little bit without these tools, how much of this building could be seen, I suppose.
So if we took a look at the broad conclusions to be drawn from this, in terms of shading, assuming a hedge height of 3 metres, the driveway will be extensively shaded virtually all of the day during the winter solstice. Is that the key point you're making about that?
That's correct. So 3 metres would be the maximum height of the hedge, whereby there would be a fraction of sun on it on the shortest day.
Yep. Okay. And in terms of the building platform from eye height, as you've done it here, the viewer on that property will see an expanse of the roof of the proposed dwelling. So if you're looking out in front of you like that, you'll see the roof of the dwelling sort of sitting there in front of you.
That's correct. Yep, it would be looking down onto the roof of a proposed dwelling.
No, I don't have any questions. Thank you for clarifying the way to read these maps.
No problem.
That's helpful. Once we've got clarification, that's very good. Thank you for that.
I'm sure your site visit will help when you look at it to
Yes.
the scale of 1 to 1.
Okay. Well, thank you for your evidence. That's very
Thank you.
helpful.
Thanks, Chris. So my next witness is Mr. Bartlett. And Mr. Bartlett will read out his personal evidence that was provided this morning.
Yep. Good afternoon, Commissioners.
Good afternoon.
I'll read through it because it's not that long, but pretty well.
That's fine.
Yeah, everything's been touched on. So in 2010, we purchased the property. My wife had grown up in Queenstown, and I've got a long history with the area as well. We'd worked many years overseas to come back and live in this area. We'd often driven along Mulligan's Road and admired the scenery, and particularly where we are, we couldn't believe that property to come up for sale there that we could afford at the time. We'd witnessed many places overseas. I've worked extensively all around the world for the last 25 years, seen many places that have been ruined. And it was obviously nice coming home to a place that's still particularly untouched compared to other places in the world. We enjoy our views in the surrounding rural area. They're outstanding, and we always appreciate them. I'm strongly opposed, and obviously my wife and family are too, to the consent application because of the adverse effects that it will have on my family's rural amenity and the use and enjoyment of our property above and beyond the adverse effects that we've recently experienced in the last 2 or 3 years with the new owner. Well, not the new owner, but his choice of tenants. As you know, my property is directly south of the applicant's property, and we share a common boundary, which is lined with the trees that we're discussing. The end of my driveway runs alongside the common boundary before turning up towards my house. My property is well elevated and sits higher than the applicant's property. Our house is a 2-story, indoor-outdoor living. The outdoor living has been designed to be used year-round. And it's situated at the same level as the second floor. The house is north-facing and looks out over the applicant's property towards Coronet Peak and then up towards Arrowtown. The proposed building platform for Lot 2 will be very close to our common boundary, and comparing other dwellings in this zone, it's probably one of the closest. We will look out at any house that gets built at the platform. The topography of the area screens the applicant's existing house. You wouldn't know that house was there unless you went down to the valley floor and seen it currently, even when the hedge is cut down. Currently, our rural view is practically unobstructed and not affected by any light spread from neighbours at night. The applicant's paddock, where the proposed subdivision had traditionally been used for grazing animals, the only noise heard was from sheep and horses, which really gave us the feeling of living rural. And this is always commented on by people who come to stay or visit. Since the applicant's purchase of the property, there have been 3 different tenancies, all having noise complaints lodged with the council by other surrounding neighbours. The first 2 tenancies were eventually cancelled and the tenants were evicted due to the irregular parties. We are particularly affected by the noise created below when considering the elevation of our house overlooking the applicant's property. Our house is uniquely positioned under a large rock cliff, approximately 40 metres high behind us on the south boundary, which seems to further amplify noise created from below us. We have regularly heard people recently while standing on the proposed build platform. We are obviously concerned that another dwelling much closer to our house will make these issues far worse, and we will regularly be disturbed by noise. When we purchased our property, we understood we were buying in a rural area where rural amenity was to be protected, and did not anticipate a development like this would be acceptable at any time. The last part of my driveway runs uphill at approximately 10 degrees slope along the common boundary with the applicant's property before turning up to my house. When the trees on the applicant's property along the boundary are above 3 metres in height, as they currently are, they shade 50 metres off the sloped section of my driveway in the winter months. This causes ice to build up on the driveway because it is not getting any sun. The shading problem occurs after some consecutive frosts or any snow, so that depending on the winter, and the problem can start in June and it can remain through to late September. A medical incident actually happened around in September. I think it might even be in October when we had our first problem with it. When the sun is able to reach the driveway for several hours a day, it generally is enough to stop the accumulation of ice, as the photos show in my evidence. I've taken photos which show ice has formed on my driveway in the winter due to shading. The photos show the shading problems in the winters of 2011 and then again the previous winter of 2021. In between these years, there were no major issues with shading due to regular tree maintenance. While we fully understand what living in an alpine environment can mean in winter conditions, as can be seen in the attached photos, the winter sun thaws everywhere else on the property, including the applicant's property, very quickly on this north-facing hill, and only ice remaining is the shaded area on the driveway, which is the only possible access to our house. The trees causing the shading are the only evergreen trees on both sides of the boundary. All other trees on our boundary lose their leaves and do not block the winter sun. Practically, the ice causes me and my family issues in both a safety hazard and a restriction on our use of property. There are times in the winter when we cannot drive up the last part of our driveway and instead have to park our cars down the driveway and walk up. On a rural property, this is not easy or ideal. Walking up and down the driveway to our cars over ice is dangerous, and there is a risk to my family slipping or injuring themselves. Previously, we've had vehicles slip off the driveway into the fence in the icy conditions when the trees have not been kept maintained. I often work out of town, and my wife has been reluctant to use the driveway in these conditions with our young children in the vehicle. On one occasion in August 2011, we needed an ambulance to access our house due to my son's medical condition. The ambulance could not get up the driveway, the last part of the driveway, where these trees were shading, and an additional 4-wheel drive ambulance was called in to assist, but was also unable to access the house. So the patient was carried down the driveway over the ice. This experience was very distressing for my family. Taxis and service and maintenance vehicles have also been affected, and we have a real concern if there was ever a fire that emergency vehicles would not be able to gain access to our house. The trees are currently 5.5 metres tall and would normally have been trimmed by now. One unmaintained section, which are now in excess of 20 metres tall, now shade a fenced paddock at the southwest corner of my property, rendering it unusable. Before the applicant purchased the property, I had an agreement with the previous owners where I kept the trees trimmed to 2 to 2.5 metres in height. By trimming them every 2 years at the 2 to 2.5 metres in height, the trees do not cause shading issues and do not cause ice build-up on the driveway. The driveway predates the trees being planted. We purchased our property in 2010 and first had issues with the access during winter of 2011. We were allowed to trim the trees to resolve the problem and have maintained them up until the point of the applicant purchasing the property. Since the applicants purchased the property, they have not allowed me to trim the trees unless I would sign off on their proposal. Because I have not been able to achieve a solution or resolution with the work I've done the work necessary to initiate proceedings in the District Court under the Property Law Act 2007 to get an order from the court requiring the trees to be maintained at 2 to 2.5 metres in height. I will commence the legal action if this is the only way to get these trees sorted out. The applicant's position that there will be no adverse rural and visual effects relies heavily on the extensive tree coverage on the applicant's property, which will help to screen the proposed house on the lot 2 from view. This is a reference to unmaintained trees along our boundary. The applicant also proposes to use further tree planting for screening. It is completely inappropriate to rely on these trees in support of the application because of the serious issues they cause us in the winter. And to plant more trees near the boundary will only make the issue worse. Screening trees also do not resolve other issues we're experiencing, like noise issues. I appreciate the applicant is now proposing to keep the trees near our boundary maintained at 3 metres in height. There are 2 issues with this. 3 metres is the maximum height the trees can be in the middle of the winter to prevent shading issues. Practically, the trees need to be trimmed at 2 to 2.5 metres in height, so whoever is in charge of the maintenance can wait several months before the trees get to 3 metres and need to be trimmed again. It is not practical to be consistently trimming these trees at 3 metres, as this would require constant upkeep. If the trees are at 3 metres, we will be able to see the house built on the proposed building platform, along with any other structures and activities associated with the dwelling, then affecting our current rural outlook and amenity as discussed further below. Discharge of wastewater to Mill Creek catchment places further stress on an already fragile environment. There are several freshwater bores in close proximity downstream to this proposed subdivision. The groundwater permeability in this area is extremely high. Further pressure of additional wastewater sewage discharge to this type of ground is very concerning when we already have had some high E. coli readings in the drinking water bores in the past. Septic tank sewage systems require maintenance and can be problematic if not correctly used. This is very concerning when neighbours are drawing groundwater close by for drinking without treatment. No additional wastewater discharge should be allowed to this particular catchment when considering the huge pollution issues Lake Hayes and its catchments are currently facing. And at a minimum requirement, the applicant's out-of-date septic system should be upgraded anyway. Any further development and increased housing density anywhere in the district should not even be considered unless there is already an established waste and freshwater infrastructure available for connecting to. The impact of smoke pollution from indoor and outdoor fires has not been addressed in the application. In the past, there have been contained fires for tree trimmings, etc. on the proposed subdivision site, and smoke almost always disperses uphill as would be expected. Generally, burn piles have been a rare activity on the applicant's top section as they have been on the valley floor portion of their property, so the impact has been reduced. If a house was to be built with approved fires for heating, and it would have a dramatic effect on our air quality. Generally, the problem is worse during cool, calm days in the winter months when there is more likely to be a regular use of a fire for heating, and also being a time when burn piles become a permitted activity in this rural zone. Once again, due to the topography of our house positioning overlooking the applicant's property, this only magnifies the problem. I suffer from asthma and regularly use prescription medication to control the condition. My 11-year-old son also suffers mild respiratory problems and at times and is prescribed an inhaler to use as needed. Smoke is a trigger for this asthma. Previously, when the boundary hedging has been traditionally maintained to the required height needed to protect our winter driveway access, we have had a view to ground level where the stock could be seen grazing on most of the proposed building platform. If there was to be any type of house built in front of us, we cannot see how any screening or additional mitigation measures could adequately protect our rural amenity and practically unobstructed views from our upstairs indoor-outdoor living areas. Because the trees along our boundary need to be maintained at a maximum of 3 metres to prevent shading effects on our driveway, our opinion is that it is not appropriate to have a second dwelling on the applicant's property so close to our house. It is clear from Mr. Hansen's modelling that the trees at 3 metres we will be able to see most of the proposed building platform from our outdoor living areas, which look out onto the platform, and our indoor living areas too. Even with the trees at their existing height of 5.5 metres, we will be able to see part of the platform from our east and west decks. In a supposedly protected rural living environment, it is not acceptable to be in such close proximity and have our amenity affected so greatly. We believe the applicant's evidence has attempted to downplay and minimise the potential impact this proposed subdivision could have, and they have not given a balanced view of its potential impact. There are only assumptions made about the proposed mitigation measures with regard to hedging and building heights. There are only assumptions about noise, and the applicant doesn't seem to have considered how much more a property is affected by light, noise, smoke pollution, and impact on views in an elevated and overlooking position such as our home is. While we do live in a small cluster of houses within a protected rural zone, it is currently considered well balanced and, as stated in the applicant's evidence, has very low capacity to absorb additional development. If the district plan rules are not adhered to in such situations as this, and these type of purely speculative developments proposed by the applicant are permitted, then gradually these small clusters will change into larger clusters, which can eventually turn into an urban sprawl. Then this special part of New Zealand will be lost forever. It's disappointing that we now find ourselves at a large personal and financial cost trying to safeguard and preserve this rural amenity for future generations when there are district plans in place that should serve all in better protecting this district's rural environmental assets. We find it completely unacceptable that our rural lifestyle, health and well-being, and rural asset would be affected by further urbanisation around us when there is an abundance of usable land around the district where this land use activity is permitted within the district plan. And this is why we strongly oppose the application in full and seek it to be declined. And saying that, I'd really like to see you guys visit there this afternoon. I think it would give you a better idea about what we're actually talking about. Thank you.
Thank you very much.
I've just got a couple of questions, and thank you for your evidence or your submission. Just on the water quality matters, had you read anything of Ms. Baden-Hopp's evidence, and does that appease you in any way, having read that document, or is it still very much an issue for you?
Yeah, well, I mean, there's no reference to even the distances of what the neighbouring freshwater bores are set at from where they'll discharge wastewater. You know, like it would have to be a long way away. I mean, when we get heavy rain, the permeability of the ground, I don't know how it's measured, but the water lifts the bore concrete lid off its base, and it hovers like a flying saucer. That's how much water is flowing through the ground. So, and then just up the valley from us, and you know, with only a few meters really, there's sewage being discharged into the same catchment, and we've already got what, 1, 2, 3, 4, 5 houses discharging now, and we're we're going to have another one adding to it. I can't see how you can mitigate against that. There needs to be a surge system out on the Long Mulligans Road if they want us to keep building houses the way they are. I'm not obviously an expert in groundwater, but I do work underground. That's my profession, and I know how water can move through the ground.
And so the other question is just trying to understand your position is really the trees need to be lowered, but if you lower them, it increases visibility of the house that on the platform. So you're kind of stuck between the two. Is that kind of apart from the other rural amenity effects? I understand those clearly. It's just the balance between visibility and shading. It's very finely balanced, trying to find the solution there.
Yeah, I know when the trees are trimmed to the correct height, we can see, particularly in the winter, because there's not much weight being put on the seasonal views, and like there's several months of the year where there's a lot of those trees that we probably rely on for shading now and on the applicant's property, and obviously our trees as well, that lose their leaves, and it's quite a different scene in winter time when you come to our property. It's very different. And like we've obviously got some trees that are screening for us currently. I mean, but one of them in particular is causing drainage issues. It's a large oak, and it, really was going to come out a couple of years ago. But since we've got wind of this, we've sort of hesitant to remove any trees until we see what the outcome is of this. So, I mean, I don't understand how a hedge at 3 meters can screen a house on a build platform that we see stock grazing on in the winter. I don't understand how how the screening can be effective.
Okay, thank you.
I've got just one question really. Is the issue really for you, issues like, say, tenant behaviour, noise, cars going past, that could be experienced by anybody on a rural or urban property. Is it your contention that the problem, well, the reason that raises a problem here is because the lot the applicant seeking to create is so small, any dwelling that's on it is inevitably going to be close to neighbours? Is that really what you're saying? Whereas if it was, say, a 4 hectare lot or a 5 hectare lot, you could plonk the house a lot further away. Am I understanding that correctly? Absolutely.
I mean, it's hard to choose a good tenant, and I'm not obviously, he's had a bad run, but it's obviously shows that how noise can affect people, even on an existing dwelling that's so far away. And I couldn't imagine what it would be like to have that dwelling positioned to where they want to put one now. It would have a huge impact on us.
Okay, well, that's good. Thank you very much. Well, thank you for that evidence. It's been very helpful.
Yep, thank you.
Yes. Oh, yeah.
Okay, so what we'll do now is I'd like to take a 10-minute adjournment. Just before doing that, though, I'm just looking at the time, and this is certainly not a criticism of anybody at all. We take whatever time it needs to take, but it may prove difficult to get out to that site this afternoon, so it may have to be tomorrow, and I hope nobody has any problems with that. I haven't spoken to my colleague yet, but looking this afternoon, I have a commitment at 5:30, so I could be a bit pressed for time to get there this afternoon. So in the meantime, I'll just take we'd like to take a short adjournment of 10 minutes, and then we'll come back. I think we've got one more submittal or two.
We've just got Mr. Saville, and his evidence is only 3 pages.
That's fine. I'm not wanting to rush anybody along. I'm just explaining that in terms of the site visit, that was all. Okay, thanks very much. We'll take an adjournment. Inspector Galloway, we're ready to continue.
Thank you. So our final witness is the submitter, Mr. Alistair Seville.
Hello, Commissioners Nixon and Sinclair. Thank you for having a hearing. Taking my hearing. My full name is Alistair Seville and I'm a registered master builder. I live in 702 Melligans Road, along with my wife Diane, and have done so for the last 21 years, where we raised our 3 children and where we have enjoyed all the benefits of living in the rural countryside. We oppose the subdivision lot number 2, subdivision lot 2 at 752 Melligans Road, due to watching other areas in the Wakatipu Basin being carved up and overpopulated, such as Speargrass Flat and Lower Shotover Golden Triangle, with some sections not bigger than what you'd find in an urban subdivision. The boundary to the applicant's property is in fact 12.5 metres from our kitchen living room, and between that is our outdoor barbecue area where we spend most of our summer days and afternoons. The proposed building platform is a mere 40 metres from the boundary, directly out through an adjoining hedge. To make matters worse, the proposed driveway leads straight up to our lounge in a direct line, with a passing bay outside our lounge. So we will not only have headlight glare through the hedge, but consistent gear changing due to the grade of the road directly outside our outdoor and living area, along with dust if the road is not to be sealed. With the close proximity of the proposed house, we will also be subject to noise over and above what should be reasonably expected in a rural setting. Over the last couple of years, we have had issues with the existing house on the property over noise, which is 80 odd metres away. It was to my understanding there'd be no further development on Melligans Road after the Denniston subdivision was granted, which is a neighbouring property. That is why it is with some dismay to see the proposed subdivision in the valley. As Mr. Espy notes for the applicant in his evidence, Melligans Valley is described as a relatively open, gently rolling valley, predominantly in working pastoral land use, making its land highly visible and visually coherent from Melligans Road. This has a very low capability to absorb additional development, and that was from Mr. Espy's. While the applicant has gone to some trouble to argue there will be no effect on the rural amenity of neighbours, this will not be the case, as there will be an extra house with 8 to 16 extra traffic movements a day, and a zigzag access way cutting up a natural hill that will look not much better than the bike park across the road at 833 Melligans Road, which adds to the effect on the visual amenity of the neighbours. Noise from an extra household will affect the neighbours in close proximity who have moved to and bought a house in the country to have no neighbours on their back door. As said earlier on, we have had issues on 6 different occasions with the neighbours, the previous neighbours and the existing tenants of the existing house. Our visual amenity will be affected if, as Mr. Denny, if the hedge on our boundary is allowed to grow to between 5 and 7 metres. At present, we are approximately 1.5 metres below the finished ground level of the hedge. A historical verbal agreement that was in place between the original owners of 752, Jim Hunter, and 702 Melligans Road, who was Awena Watts, when we bought the property 21 years ago, was that only a single row of trees would be planted by Jim on the boundary directly outside our house and would be kept to a height of 2.5 metres. So effectively a 4 metre from tree height to finished floor level of our house. If these trees are to be kept at 5 to 7 metres on our living side of our house, only 12.5 metres from the boundary, we would see no sun on our eastern side, being our morning sun, to the north, which is totally unacceptable. With an expected 4.45 million cost to make Lake Hayes swimming pool again, as reported in September last year, Lake Hayes has suffered up a build-up of human activity, which includes fertiliser and septic tank effluent, which has led to the algae blooms and left Lake unswimmable. Is it not time to stop all development upstream and preserve what we have, as stated by the Otago Regional Council? The conservation of Lake Hayes resource is a regional and national importance, both economically, recreationally, and for its intrinsic and scenic values. In 2018, in a hearing, the proposed housing developments at Waterfall Park, the District Plan Review Hearing Commissioners recommended that the land in the Mill Creek catchment needed to be as low density as possible to protect Lake Hayes from further deterioration. So why add another septic tank upstream in Mill Creek catchment? Lake Hayes is now crying out for help. I don't oppose development as I'm a builder and it's part of my position, but it should be in a controlled environment such as an urban subdivision or development in a rural environment on bare land or the removal of an existing dwelling, not a development which is trying to cram two properties into one, which to me is just greed, especially when the applicant does not appear to intend to live there and has not been able to address the neighbours' concerns regarding the effects on their amenity. As a landowner who bought and invested in a property in the country 21 years ago, and to have a rural setting, the meaning of rural from Google is an important one to remember. An open swath of land that has few homes or other buildings and not many people, characteristic of the countryside rather than a town. Thank you.
Thank you.
Yeah, just thanks, Mr. Saville. Just a couple of points of clarification. Just when you were reading through in paragraph 4, you referred to 40 metres from the boundary, but our sheet of paper says 60 metres.
Yeah, I heard it corrected before. I actually stepped it out, so that's where I got my 60. I probably took too big of steps.
Okay, so it is 40?
That's what I heard earlier in the issue in the dialogue, yes.
Okay, and just the next point down then, paragraph 6, you refer to 200 metres.
Yeah, again, I heard earlier that it was the existing
80.
Yes.
Okay. And just on paragraph 11, you quote the regional council. What was it? Yes, quote about Waterfall Park and the regional. Yeah, regional. You quote just before that. You quote something about Otago Regional Council, quoting about the conservation of Lake Hayes. Where does that come from?
That was in. It was on the website of the Friends of Lake Hayes. It was an article on there.
In an article.
Yes, correct.
Okay. That was all I had. Thank you.
Yes, the only question I would ask is, my colleague asked the previous submitter, Mr. Bartlett. There was evidence this morning presented from Ms. Badenhoff about the effects on water quality in the catchment. Did you hear that?
Yeah, I did. Look, I've put in my fair share of septic tanks over the years, being a builder. And, you know, they'll say you can drink the water that comes out out of a septic tank. I've never seen a salesman yet try and drink that water or want to drink that water, but they sell you that dream. There's no way the water that comes out of a septic tank, it leaches, it will find a water stream. And even if they replace one down there, which is a great thing to go and do, the water up top here will find its way down to a riverbed. You know?
Okay. Well, thank you very much for that. That's very helpful. Now we'll move on. I think it's time for the council to give their response. Before they do, is anyone in the council happy to start now, or would you like a few minutes to prepare?
No, we're happy to proceed now.
Okay, that's fine. We'll feel free to do so.
Mr. Shawland has time restrictions, so he has requested to go first, if that's okay. And then
Yeah, I thought that was the case.
Yeah, and then I think I'd like Mr. Denny to speak, and then I'll go last, if that's okay.
Thank you.
Ready to go, commissioners?
Yes.
Sorry.
Thank you.
Sorry, my apologies. So just going to touch on a few points that have come up today. There was a query around the earthworks volumes. I had an opportunity to just look back at the application, see where there was a discrepancy there between the 1,000 of cut and 300 of fill that both Mr. Hopkins and I reported on. The original AEE included those numbers. Subsequent AEE was updated to 1750, and I hadn't picked that up. I'm not sure why or what the change was. It doesn't impact materially on any of my proposed conditions.
So that's 1750 cubic meters cut and fill.
That's in the latest AEE version.
Yeah.
Okay, thank you for that.
In terms of water quality and the applicant's proposed revised condition around the stormwater disposal from the roadside.
Is this condition 11B for?
Yes.
That's that one. Yep.
Yes. I'm quite happy with the revised condition, and I'm happy to work with the applicant to tweak that to ensure that we get clarity around the extent of the level of treatment provided. I think that's we can easily come up with something there. And they were offering to put something on a plan. So perhaps we follow that process. If they propose their plan and a condition, we can have a look at it, and I'm sure we can come to a conclusion on that one pretty straightforward. In terms of the level of treatment associated with the proposed solution, I'm no expert in that. Whether 75, a level of 75 units of turbidity was acceptable or not, I don't know, and I defer to Ms. Badenhop's expert opinion on that. She says that's the appropriate level, and that achieves a neutral outcome, then I'm happy to accept that. And so I think that's that matter. And in terms of lot 1 and the septic tank upgrading, obviously it's been a bit of discussion around that. From my perspective, undoubtedly upgrading it will provide an improvement quality. I don't think anyone's arguing that. The applicant has said that themselves. So it's really just comes down to the timing of that improvement, and that's really a matter of how you interpret the policy and the level of improvements that are needed by that. And so they're saying that they're going to improve it by providing the planting. We've heard that evidence, and that makes sense to me as well. I would expect there to be an improvement from that. Again, not an expert, but just understanding how that works. And then the promise of upgrading lot 1 in the future. And yeah, as I said, that's a timing matter. So whether that meets the policy or not, I don't know. We'll leave that to you. And dust came up, and I would just say that I concur broadly with what Mr. Hopkins was saying, but I'll also just add that I think it's probably a pretty low risk. It's a low speed environment. It's a short length of road. It's got bends in it. You're not going to be ripping up there too fast, and it's a pretty sheltered area. So the risks, I would have said, were pretty low.
Is that risk of having a dust effect?
Yes, of the dust being generated. I mean, it's you know, if you're driving on a gravel road, there will be fine sediments that will lift in wind conditions. I'm just making the comment that in this particular case, it's not a high risk sort of scenario. You're not talking about a large, long road where speeds can be higher, which generate a higher level of dust.
Okay, and that, just following on from that, therefore, there'd be no need to treat it in any particular clean, I think it was clean gravel, periodically updated, I think were the words, or?
It would provide an improvement by undertaking that. I certainly would tend to that as a solution as opposed to any kind of treatment. Yeah.
Okay.
Thank you. Any other points you'd like to?
No, that's all I thought that was relevant to discuss. That come up.
I'll just start with the question. The issue about the policy and the plan, which is 24.2.4.2, which is often cited, particularly in terms of Lake Hayes, restrict the subdivision development of use of land in the Lake Hayes catchment unless it can contribute to water quality improvement in the catchment. Then it goes on to say commensurate with the nature, scale and location of the proposal. So it's not, it doesn't read as a ban on that activity. It basically is related to the nature, scale and location. Are there many people these days who are actually undertaking a subdivision or building a dwelling in the catchment which is not on a reticulated supply? I would have thought the number of new houses, this is an application for a building platform which have a house on it, but are they getting rather rare now in this catchment, or do they still happen from time to time? So all the building service.
Yeah, I think it's still happening. Just thinking about my recent 5-lot subdivision over the road from there, just below Coronet Peak there, that was all unserviced. Went granted consent maybe 1 or 2 years ago that I was involved with. It's no reticulated services that go past there, so any development in that particular area is someone, I think I heard someone say Millbrook is probably the extent of those reticulated services in that direction from Arrowtown, and Arthur's Point, old Arthur's Point, where the just at the end of the development there before Coronet Peak, that's where the services finish in that direction. So there is a big gap.
Okay, all right. That's
I just had 2 further questions. One was the water quality report. Is there, do you have any thoughts on whether, you obviously just heard you say that you're not an expert in that field, and I understand that. Would there be any merit in having that report sort of peer reviewed, or thoughts on that, if that was necessary?
I haven't heard anything today that is significantly contentious, if you like, or significantly higher enough risk that made me thought that was necessary. As I said, I was happy to accept Ms. Badenhop's expert advice. The need to go for a peer review comes down to the level of risk and consequences. Again, I'm not being an expert, it's a bit harder for me to judge, but in my experience, it didn't jump out at me as being necessary.
And just my other question was on understanding the EMP process, the environmental management, is that what it is? Environmental management plan process. And it seems to me that I think you've called it a medium risk drilling earthworks in the vicinity of Mill Creek. And that somewhere along the line, we've got a little bit of detail about on-site mitigation in terms of what happens with the earthworks. But it seems that a lot of that fine detail would come into council in the event that this would be granted at a later date. What assurances do we have now that what would be likely to be in those documents that we can sort of rely on in terms of how to mitigate adverse effects from sedimentation runoff into the creek?
Did I say it was medium?
I think I've read somewhere that it was medium, and maybe in the section 42A report. I might be wrong.
Well, I would say it's definitely high.
High, okay.
I was just looking. Sorry, I was just scanning through my report. I don't know, but just given the Mill Creek and its challenges, I would definitely say it's high in terms of the guidelines. It's a sensitive receiving environment. It's within 50 metres of the earthworks, so it definitely hits the criteria for high risk. So to answer your question, what assurances do you have now? Well, I can put my hand up and say I'm a bit of an expert in this area. I had the training in this area. I am accepted by council as a suitably qualified, experienced person, and I am comfortable that the mitigation measures can be put in place to achieve the environmental outcomes necessary. For the high risk process, there's a suite of conditions that require information to be provided up front that's reviewed and accepted by other experts, and the higher risk ones require a high level of monitoring throughout the process and reporting on an exception basis. So I guess to answer your question, is it any greater confidence for you to know that there's a set of conditions there than there is on anything else? You know, the process is in place. It's been well established now. It's been policy's been in place for over 2 years, 3 years now. And as I said, I believe that with a well drafted and implemented environmental management plan, that the risk can be mitigated to the level that's acceptable.
Thank you for that. That was all I had.
No, thank you. That's very helpful. So who wants to go? It's Mr. Denny next, is it? I understand.
Thank you.
Thanks, Mr. Hewen.
Hi there, can you hear me?
Very faintly.
Very faintly. So, yeah, that might be better.
Can you hear me?
And you must be along in a land far away.
I get no response. Can you hear me?
Very faintly, Mr. Denny. Where are you?
No, so we've heard everyone else's. Can you hear us?
No.
No, you can't. It must be at Richard's end because we're all right this thing. No.
No.
You can't hear us either.
No.
Everyone else is all right, so it has to be Richard's end, doesn't it?
Can you hear us, Mr. Denny? I don't think Richard can.
No, I don't think Richard's hearing us.
Oh.
Hi there, can you hear me?
Yes.
Hey,
Yeah, very low though, Richard.
still
Can
hear
you
me?
turn it? Can you turn yourself up?
That's right. Have any sympathy? I hate this technology.
Right.
Yeah.
Still hear me?
Yes.
Yeah, that's better.
We can hardly hear him or anything he's trying to say, Commissioners, if that's any help.
Yeah, nobody's hearing you, Richard, very clearly,
Very low.
including the other parties.
I can hear you now. Right, can you hear me now?
A little bit. What do we do?
The only other thing we could do is,
Speakerphone?
yeah, maybe we can just go onto a speakerphone. That's a possibility.
Should I go and get Trish?
Yeah, I was thinking get Trish and say that we're not picking him up at all.
Speakerphone? Yeah. It brings my phone. Brings your phone? What? It brings it here? Yeah, maybe something like that. Yeah, it's going to bring. Richard, can you see us?
I can see, can you hear me now?
Yes, a little bit.
Oh. I can see
Anyway.
you. I can hear you. I
Oh,
don't know if you can hear me.
yeah, you just your
You come on the
volume.
screen. You weren't on the screen before. Now you are.
Your volume's very low.
Maybe you should turn the screen off. Not that I want to hide myself or anything, but it might help the volume.
Trish has just suggested that you ring her phone, and she was going to bring the phone in.
Hi, Trish. Hello. Yes. Awesome. So I can't hear.
Okay, you right? And how will the other submitted participants hear? Trish? Well, we're going to ask. Can you speak now, Richard?
Yep.
Yeah.
Yeah, we can.
Where's the volume for this meeting? Is it over there? Where's the what? Can someone else indicate if they can hear Richard, please?
Speaking.
Marie, can you hear Richard? What about the applicant?
Yeah, I can. He just has to mute his own microphone, otherwise we'll get double feedback.
But he's on a cell phone.
No, now he's muted. That's good. Yeah.
Okay,
Yeah.
how's that?
Is he currently talking? We can't hear him.
We're not hearing anything if that's.
Can you just say
You're not hearing anything at all, Mr. Gordon.
maybe put the speaker, the phone by the speaker? Okay, can you say something else, Richard?
Richard here, can you hear me? Can you hear me?
No, it's not any better, is it?
It's not much better.
Can you hear us, Richard?
Yeah, sorry.
But the applicant can't hear. No. The applicant can't hear you, Richard, so we're just working through that.
Right, yeah. That's weird because it's been fine all day. I've been hearing everything fine, and yeah.
That's
Oh,
better.
that's better. Oh,
That's much better.
Okay, we're getting a more positive now. I think we might be ready to roll.
All right.
right.
Phone in one hand, earmuffs.
Just as well we can't. Oh no, I can see you.
Yeah, technology is wonderful.
So I might be on. Take the earmuffs off, you get some feedback. All right. So I'll just crack on while we still can. Just touch on a few things raised today. The first thing was discussion on the reserve as a public viewing point. My understanding it's Esplanade Reserve, so it's under the Reserves Act. I know it's a valid public viewing point to be considered. There's been a lot of discussion today on hedges. To my mind, the hedges, because of what they are, in terms of species and their contribution to rural character, I'm not fussed either way that they're or not there in terms of rural character. The only value I see in the hedges is the visual screen they think they have on neighbours. So if there's an agreement to be made between neighbours on relative heights, that's fine. It's between the neighbours, but in terms of the broader landscape, I don't think the hedges are of any particular value. And just on planting, it's discussions about 2,000 plants to be planted. This is to deal with water quality effects, not landscape effects. But having said that, they are a potential positive value to the landscape. So just to be clear that it'd be useful to have a landscape plan showing locations. So they're recorded where they are on the landscape and that they're maintained for the rest of it. Ideally, from a landscape point of view, I think it should be in the Esplanade Reserve, but that's a matter for council to resolve. Or ideally, I also think to the north, the southern side of the creek, where they'll have some bit of visual mitigation value, because there is also a recommended condition might have planting on that side as well. So there could be a potential double value there, but at the end of the day, it's a water quality mitigation measure. The final thing is quite a tough one to resolve, and that's this whole thing about visual amenity versus rural amenity. To my mind, it's a key part of this application, that this development is, in terms of visual effects, they're quite low overall. The big thing for me is the character effects in terms of what scale you perceive that character at. From the landscape character unit perspective, which is a broader view of the landscape, I guess you'd say, the character effects probably not as high. But in terms of how the neighbours experience that character as such, I think they are a lot higher. To my mind, issue of sense of spaciousness. The definition of that, where I see it, is the spacing between residential dwellings. It's not so much vegetation or landscape elements. It's actually those. A rural sense of landscape is to a certain degree from the distance from other residential activity and development. It's quite key in this one. There's a lot of emphasis in the LCU about the pastoral landscape, the big open paddocks which are nearby, and it's obvious this development's going to have very little of any effect on that. But I don't think it sort of eliminates potential effects in terms of the woodland type areas that we're seeing on this site, where you have existing rural living development. There's still a rural element to those areas that needs to be considered. And I think rural spaciousness comes within that in terms of having a sense that you're still in a rural environment, you're still away from neighbours and what have you. I think this development is sort of a little bit, it's obvious in terms of submissions that have come through that the surrounding properties that are mostly affected by increased development are losing some degree of rural amenity because of the density. But I'll have nothing further. I have to answer a few questions.
Yes, thank you, Mr. Denny. So you've just been talking about the very point I wanted to raise with you, which relates to rural density. Now, the lot being created here, bearing in mind this is not building on an existing vacant lot, it's creating a new lot on which somebody wants to build. And I guess it may sound blindingly simple, but if the smaller the lot is, inevitably, if you put a dwelling on it, the less space the dwelling have to rattle around in, if I can put it that way. It's inevitably going to be, you're going to have more and more of a sense of proximity the smaller the lot is, and that seems to be the message we were picking up from the submitters. So I take it that's the point.
Yeah, absolutely. I think it's a function, pure function of size of lot to land use. So the land use is going to be predominantly more residential land use rather than having this sort of contribution to rural land use or rural character. So you're having a greater presence of residential development and residential activity within that localised area. And that's going to change the rural amenity for neighbours and does have an effect on their perception of rural landscape character in a localised context.
I just had one question, Mr. Denny, or two actually, and regarding the term spaciousness, is there any guidance anywhere in the plan on what that actually, what it means in terms of on the ground, in terms of is there any distances that we should be looking for, or what is typical in a rural area?
I don't think so. I mean, Pete may have a better answer for this one than I have. I am aware of a Rama Court decision in Wanaka that talks about spaciousness and difference between buildings. I couldn't give an exact number. I'll send that through if you need that, right?
Possibly. Would that be helpful?
Possibly, yeah.
Yeah. And the other one is typically in a rural environment, what's sort of some guidance on separation distances between dwellings in a rural in this Wakatipu Basin Amenity Zone?
Oh God. I don't think it's as scientific as that.
Right.
Yeah, it's almost a relative kind of thing, really. And I guess under this LCU and under the amenity zone, it kind of indicates that, well, especially under this LCU, that distance is, just quite sensitive.
Okay. And my last final question, I understand now that the size of that curtilage area of 3,000 square metres came from a recommendation of yours. Is that sort of like a general size of curtilage areas, or is it specifically tailored to this site in particular?
Curtilage areas can vary a lot throughout the rural district. I think 3,000 is kind of like an average, I guess you could say. I mean, it's in proportion to the scale of the lot, the landscape context and stuff. for this site, it's more about containment and avoiding the slope, stuff spilling down the slope.
Right.
It almost, lot the size, it almost becomes redundant because the lot's so small.
Right, so when you proposed that, it was about the containment and stopping the visual effects sort of sprawling down the slope, not necessarily about, you weren't thinking about residential noise and trampolines and things like that.
No, because I don't think it would be affected in that regard, because a lot of those effects are beyond visual, you should say. I was going to say. Yeah, I mean, because the proximity so close up with residential dwellings, I think fine-tuning your curvature along the sides becomes slightly pointless.
Okay. Okay, thank you, Mr. Venning.
Oh, sorry, Mr. One further question is, from me is, you probably heard earlier on, quite a lot of attention's been focused on the fact that if you look at LCU1, that this is like a little subunit of LCU1, which is a rural residential cluster and can be differentiated from the rest of LCU1. Is that a view you subscribe to?
So what was the last bit? I just missed the last bit.
It's just, it's been put to us that this particular area is not like the rest of LCU1. It's like its own little enclave or cluster, if you like. Do you think that there's basis for treating it differently?
To a certain degree, I mean, it's still part of LC1 and it still contributes to the overall landscape. You can't totally avoid it. It's got an association with the surrounding landscape. It sort of sets a frame almost to define the contrast between the two. And I think the woodland in itself, the dominance of it is the trees. And as soon as you have buildings and residential activity becoming increasingly more predominant, that woodland contribution to the overall character starts to diminish. So I don't think these little pockets of rural learning development in these areas that, you know, supposedly have a greater capacity for soil development are unlimited.
Okay, all right. Well, thank you very much. That's very helpful. I think we can probably go to the planning evidence now. Thank you, Mr. Venning.
Thanks, Mr. Venning.
Right. Well, the first thing I'd like to address is the water quality matters. I'm satisfied that the applicant has provided sufficient information to demonstrate that the proposal can improve water quality, but there's just a few things that I'm unclear on. The first being whether Ms. Baden-Hopp's assessment takes into consideration Mr. Hopkins' proposed revised condition wording of condition 11B4, which is in regard to stormwater disposal. I'm just not clear. It looks as though Mr. Hopkins' evidence was prepared after Ms. Baden-Hopp, so I'm just not sure if she considered that in her assessment. The other thing was, it's not clear whether the effects of the proposed planting would be immediate. So in the assessment it says that the planting of 2,000 plants will remove approximately 24 kilograms of nitrogen per year from the catchment, but I'm not clear on whether those effects are immediate or whether it would take a few years for the vegetation to become established in order to remove that amount of nitrogen. And given that uncertainty, I think it would likely be more appropriate to require the upgrade of the wastewater system for Lot 1 prior to 2 to 4C approval. In terms of landscape and rural amenity, I think given that the applicant has accepted the recommended consent conditions, I'm satisfied that adverse visual effects on the wider environment and adjacent properties will be less than minor. However, I still consider that the proposal will have adverse effects on the residential amenity of adjacent properties. So whilst I'm satisfied that the building platform will be fairly well contained visually, I still have concerns with effects associated with an increase in noise, lighting and traffic. I'd also like to note that in section 7221 of my 42A report, I believe I inadvertently left out reference to 702 or 700 and 702 Mulligan's Road. In my last paragraph, I concluded overall it is considered that the proposal will have more than minor adverse effects on the owners and or occupiers of 776 Mulligan's Road in regard to rural amenities. And I'd just like to add in that, you know, that should have also referred to 700 and 702 Mulligan's Road.
Mr. Hearn, is that the Saville property?
Yes, to the west.
Okay, thank you.
I also just wanted to note, at the time of writing my report, I hadn't given consideration to the likelihood of, well, the allowance for residential flats as well. Obviously, the proposal could allow for the construction of a residential flat on each lot, which I hadn't originally considered, and that would further increase residential density, and I consider would potentially exacerbate effects on rural amenities of the adjacent properties as well. And in terms of the objectives and policies of the PDP, I consider that the proposal meets the overall purpose of the zone in that it maintains landscape character and amenity values of the Wakatipu Basin. However, in my mind, the wording of policy 24211 is quite clear in requiring the 80 hectare minimum lot size, and there's no flexibility in that wording. So I am satisfied that the proposal is consistent with most of the objectives and policies of the PDP now, with the exception of policy 24211 and 27214. And given that policy 24211 is central to the rural amenity zone, I still consider that overall the proposal is contrary to the objectives and policies of the PDP. But that was all I had, so open to questions.
And you've probably heard earlier today on at least two occasions where we've been debating, particularly with Ms. Baker Galloway and Mr. Gordon, about how we approach the 24.2.1.1, the density policy, the related subdivision policy, I think it's 24.242, and how we try and get our heads around that. It's not helped, of course, by the fact that the Environment Court decision is imminent on that matter. You've no doubt read Ms. Fifi's report, where basically, as I understand it anyway, and Mr. Gordon may correct me in his right of reply, it seems to basically balance, weigh up the various objectives and policies and look at them more or less in the round. That's how it looks like she's approached it. But my understanding, your view is that the policies on rural density are expressed in quite directive terms. I won't use the term king salmon this time, but you know what I mean. They don't seem to allow much scope for manoeuvre.
Yes, that's correct.
Yeah. Are you familiar with the case law examples that were referred to by Mr. Gordon?
Not in great detail, no.
Okay.
I've just got, a lot of my questions have been answered along the course of the day, so I've just got a couple of things to check with you, Mr. Hearn. Just want to make sure that you agree with Ms. Fifi on the relevance of the following chapters, that chapter 25 does have some relevance?
Yes, yeah, I agree. That's relevant.
There was just some differences in your between the section 42A report and Ms. Fifi's evidence. Natural hazards, chapter 28, Ms. Fifi considered that had some relevance.
Yep, I agree with that.
And she also considered chapter 29 transport was relevant.
Yes, I also agree with that.
All right. And because the driveway has been removed from the local purpose reserve, does that mean that the open space and recreation zone chapter is no longer relevant?
No, yeah, I don't consider it's relevant anymore.
Okay. I just had something to check in the section 42A report, so just bear with me for a second. Got to understand my notes. Can you just go to your section 42A report, and I have it on page 20 of what we look at, but it's policy 3.3.24 under the PDP chapter 3 strategic direction analysis, about 3/4 of the way down the page.
Was it 3.3.24, did you say?
Yeah, about cumulative effects.
Yes.
And the bottom line is that the proposal is therefore consistent with the proposal. That's what you've reached the conclusion on that. But the sentence above, I just wondered if it was inconsistent or consistent, and whether if you meant consistent or inconsistent. The sentence above, could you just read that? I wasn't sure if it was a mistake, or did you actually find it consistent? Could you just recheck that for me, that you were happy?
Oh yes, it looks like it should say therefore inconsistent with this.
Okay, so it isn't inconsistent. It's just the word you used, the word unacceptable, and then I thought, maybe it's mentioned. So it is inconsistent?
Yes.
Okay, that's all right. And was just your view on just the applicant's changes to the conditions, if you had any advice on any of the proposed amendments, if you'd had a chance to look at those?
I think what their proposed amendments are appropriate, and I'm fairly comfortable with what they've proposed.
Thank you for that.
Only just one follow-up question, and that is, and it was touched on by somebody earlier, it's the issue, and it's touched on by that policy, cumulative effects. And it comes through, I think, some of the evidence we've heard relating from the submitters and from Mr. Denny. Would a grant of consent to this application effectively push what is currently a borderline rural enclave into being a borderline rural residential enclave? Because that's basically what we seem to be hearing. Do you have any thoughts on that subject?
Sorry, can you repeat the question?
Well, is it a tipping point here which would take this cluster of houses, if you like, from being rural into sort of transitioning into rural residential?
I think in this instance, the site is quite well contained, and it wouldn't be out of character given the lot sizes in that immediately surrounding area. So yeah, I think in this case, potentially limited potential to absorb the development, and I think it would be close to reaching that tipping point, if not on it.
Is there any other comments you'd like to add at all with respect to council's case, planning issues or anything else at this point?
No, not that I can think of.
Okay, I'll thank you for the members.
For just one moment and seek a matter of clarification through you, if I may. One of the matters that Mr. Hearn said remained a concern was lighting, and I'm interested to know whether that is fixed lighting that might be associated with a dwelling and or curtilage, or whether it's vehicle headlights she's referring to.
You'd like me to clarify that from her? Yes, all right. Mr. Hearn, you heard that question. Do you have any comment you'd like to make on it?
I think the proposed conditions or the conditions accepted by the applicant would probably mitigate lighting effects associated with any buildings, but I think my concern is more with vehicles and headlights.
And a follow-up question, if I may, through you, commissioners, would that relate to the Saville property where the driveway heads towards the dwelling rather than anywhere else?
Well, from my own position, we'll talk to my colleague here. My recollection of listening to the submitters, well, I know that point was specifically raised by Mr. Saville in his presentation. I can't quite recall whether it was specifically raised by Mr. Bartlett or by anybody else.
I'm not sure, sorry, yeah.
The reason I asked the question, commissioners, is that there is maintained a low level, almost a gap in the vegetation with the Saville boundary under the requirements of the local electricity provider, because there needs to be a clear 2.5 metres of space between the vegetation and the wires. And if that is the particular area of concern about headlight pollution, then I'm instructed that my client would meet the cost of undergrounding those wires to enable that gap that you'll see on the site visit in the edge line to be vegetated. If that's the issue, and I'm not sure that it is, but if it is, then that's offered.
I'll make a note of that. I'm not sure whether the submitters are still here or not, but Ms. Baker Galloway is here, so she'll be aware of that. Okay, thank you.
I've just got one more question. Just another question, sorry. Is there, just from your site visit and your knowledge of that area, I'm not sure if you've been on other people's sites, but is there anything that you can see that distinguishes this site from other sites in that locality, which would prevent them from applying for a similar subdivision? It's to the planner, sorry.
Oh, sorry, that's a question directed at the council planner.
It's just in terms of precedent effects, being given that this is a non-compliant activity. What makes this site so different from other sites?
I do think this site is quite well contained given the established vegetation. I guess, yeah, I don't think there is a high precedent risk in this case, given that it is quite unique and well vegetated.
Thank you.
Right, thank you very much. So I'll take at this point, it's the closed for the council. So that brings us back to you, Mr. Gordon.
So there's just one thing I might like to say to assist the commission. Well,
okay. All right.
There was some discussion earlier about the merits of a monitoring condition for water quality. So I'll leave it to the commission to determine whether they see any value in that. But as far as I can see, there would be no restriction on them entering the Estuarine Reserve to undertake water quality monitoring there. I don't see that it would need to be conducted entirely within their own private land. I mean, it's a public reserve, there's no restriction on public access to it as far as I'm aware.
Okay, thank you, Mr. Don. Is there anything else the council wants to add, or?
No, that was it.
Thank you very much. Okay, Mr. Gordon.
I'd like to give a reply in writing and exercise that option. Thank you, commissioners. There's quite a breadth of information to discuss and set straight from our point of view. So I think that's best done in writing.
I would have expected you to do that. Yes, that's pretty much the case.
Thinking about timing of that and understanding other commitments that we've both got. 10 days. We're suggesting 3 working weeks, if we may. It's not as though we've got 3 clear weeks in front of us. I hasten to add.
Yeah, no, I understand that. As part of that process, whether or not, as you're probably well aware, whether or not application is granted or not, the normal practice is to ask for the applicant and the council to attempt to reach agreement on a final set of conditions. Now, you may not reach total agreement, that's fine, we'd have to make the call in that case, but if that could also form part of the reply, if yourselves and the council could liaise with each other and come up with a set of conditions. If there's any disagreement on conditions, just advise what those are and why. That would be most helpful.
Certainly.
And we'll attempt to do the site visit tomorrow morning.
In the rain.
In the rain, but there you are, that's life, is to deal with that. So, yeah, thank you very much.
Thank you, Rob.
Anything, do you wish to add anything further at this stage?
No, I don't have anything further to add. Other than to say that technically it's been very difficult to hear Mr. Denny and to understand exactly what he was saying. I completely lost his second to last answer in relation to curtilage size when he was responding to Commissioner Sinclair. But I think the recording might help us understand that.
Do you need to repeat the question?
I don't know if we can repeat the answer.
I think he said that 3,000 square metres was relatively standard.
Yeah, he said it was relatively average size, a relatively average size for a curtilage area. And then the gist of it was that he said that basically making changes that would be a moot point given the size of the site. So whether it's smaller or larger, wouldn't make much of a difference to his opinion given the size of the site.
Thank you.
Okay. Well, if there's nothing further he wants to add at this stage, I think it's time to just thank everybody for your participation today rather than your attendance. I appreciate it's a rather, I imagine it may be totally new to some of us, it may not be to others, but it's certainly a rather different way of conducting hearings than what we normally do. But thank you all for your forbearance and understanding and for the contribution that you've made. And so we'll adjourn the hearing meantime, pending the site visit and your reply in due course, Mr. Gordon.
Thank you very much, Commissioners.
Thank you very much.
Thanks to everybody.
Thank you.